Welcome everyone to September's risk management, risk reduction class. As most of you know, we do have our Irvine agents with us. We do this class regularly every month, and I present forms and changes in the law and issues that have come up, best practices. The goal is to help you keep your commissions. That's as simple as it can be. I would like you not to have any problems with your transactions, but if you do have problems, that you're on the right side of the rules, the regulations, and that sort of thing, so that we can resolve the issues in you and your client's favor and without any undue stress on yourselves. So this is the purpose of these classes. We do them once a month, usually the third Wednesday of the month. This month, we're going to be talking about one new form, one revised form. Pretty important you understand both of them. And we're also going to talk about the new regulations put out by the DRE, or the guidelines that might be a better, which are regulations explaining how the buyer representation agreements will be enforced. And so the DRE's guidelines will elevate to the level of regulation. And so you'll be required to understand those. Not a big deal. It's actually a clarification. The law was written by the legislature, many of them not real estate agents. DRE chimed in and said, let us clarify a few things. And so I want to go through that with you as well. So without any further ado, as they say, let me open up my presentation. Can everybody see my screen?
Not yet.
Not
Yes,
yet?
now we can.
Now you can. All right, great. Okay. Let me open this so I can get these things done here. Okay. All right. Okay, as everyone knows, I open up every presentation. I want to remind everybody on how to reach me. If you're working, my mission is to be available to you, and that includes evenings and weekends. Good news is I don't have a lot of other things happening in my life. And so I do have a life, as some of you know, especially when it comes to going to concerts and then doing things with my wife and my boys. But I am available most weekends, most evenings. During the business day, it's best to call my landline. That's the direct line there on your screen. Of course, you can email me anytime. That's always good. And then weekends and evenings, you call my cell. You can call it or text it. I've made arrangements so the ringer doesn't bother my wife. And so that's a good situation. You can just call me weekends and evenings on my cell. So you need me, reach out to me. I'm here to help in any way I can. All right, let's talk about the September 25 forms release. There's two forms. I'm going to cover both of them. Actually, there's a few other forms, but they don't apply to what most of you do. And then also an update on the DRE, from the DRE regarding buyer representation agreements. So let's look at the forms. The first form is a brand new form, and this is covers a brand new situation that many of you may not be aware of. Some of you may have heard about it, but it is the new requirement for closing individuals, closing organizations, i.e. escrows and title companies, to report certain transactions to the federal government, including the parties in the transaction. It's a pretty broad new regulation. It goes in effect immediately, but doesn't affect, actually it's in effect, but it doesn't affect transactions that close before December 1st. But starting on any transaction that closes December 1st or later, these regulations will apply. So you'll want to understand this, and you'll want to be able to review this with your clients, because even if you open an escrow today, if it closes in plans to close in early November. We're not going to worry too much about it. But I've talked to our escrow people, talked to Barb, and for any transaction scheduled to close November 15th or later, they're going to collect the information I'm going to talk about, because, not too often, right? Some of you may be surprised to learn that escrows sometimes don't close on time. So in that rare situation when an escrow doesn't close on time, it was scheduled to close November 16th, and it doesn't, and it bleeds into December 2nd, this reporting will be required. So escrow is going to start collecting the information a little earlier than the end of November. And we require this form starting now. This is a form that's available in in Zip Forms, and we want your clients to be aware of this. You can explain it to them. It probably won't affect them if they're going to close before December 1st. Again, if the closing is getting close to December 1st, this might have an impact. And so your clients want to be aware of it. And we want this on record because there's some reporting requirements that are not optional. So what am I talking about? Let's get into the form, which will help explain the regulation. The form, of course, is the FRR-PA, the Federal Reporting Requirement Purchase Addendum. This is an addendum to the purchase agreement. So this will be incorporated into a purchase agreement as it'll be enforced where applicable. Now, well, let me jump ahead and show you the screen. This addendum is used with only certain transactions. So not every transaction would it be used for. So the transactions that would be used for is residential purchase agreements, new construction purchase agreements, vacant land purchase agreements if the property to be improved. The intended use of the land is to put residential units on the land, 1 to 4. Residential income purchase agreements consisting of 1 to 4 units, and residential units purchase addendums if for mixed use, if it has 1 to 4 residential units. The reporting obligation under the rules issued by the Financial Crimes Enforcement Network, so-called FinCEN, beginning December 1st, 2025, a reporting person, which is the escrow company or title company, will be required to collect and report to the Treasury certain information about the buyer and the seller in the sale of certain real estate properties. And I covered those properties. There's also a certain whether financing or all cash, that's also an aspect of whether reporting is required. Now, the purpose of this is to prevent money laundering. So this is part of the AML program, anti-money laundering program that the federal government has instituted. And this is a further development in trying to prevent money laundering. One of the things that you probably are aware of, especially drug dealers, right? Drug dealers collect a lot of money and they don't have any source of income for that money that's legal. So they end up with, closets full of cash, and what do you do with it? So one of the ways to launder the money is to buy properties, and they generally buy residential properties because they're easy to sell. And so they buy residential properties and with all cash. And then when they sell it, they now have a paper trail. So suddenly the money becomes legitimate because it was the proceeds of a sale transaction. So that's the kind of the background of what's happening here. So the reporting person may be requiring the information, will be requiring all the information for applicable transactions. And this is for if there's a possibility that the transaction will close December 1st or later. So it's not just transactions scheduled to close December 1st or later. As I said earlier, they will collect information if there's a possibility that will happen, because collecting this information is mandatory. The fines for not doing it in one case is $100,000 on one part of the regulation. In another part of the regulation, it's $250,000 and 5 years in prison. I don't know of a single escrow officer who's going to risk that. So they're going to start collecting this information, even for escrows scheduled to close before December 1st, if there's any possibility that the transaction would bleed into closing December 1st or later. Okay, so the conditions that must apply. So the property being purchased is 1 to 4 residential units or vacant land where the transferee intends to build a residential unit on the land. It is also if the buyer is a legal entity or trust. So this does not affect individual buyers. Walt Klein buys a house and he's not buying it through a legal entity or his trust, then this law would not apply. So a typical mom and pop transaction, somebody is selling a house, a couple that owns a house, and now they're going to sell it and move, downscale a little bit and sell a nice house. Young couples buying the house, and they're buying it under their own name as an individual, then this would not apply. It's for all cash purchases. So again, if there's financing, it would not apply, assuming the financing is through a lender that has a reporting obligation. So what does that mean in English? That means typical lenders, your average lender, your banks and all those entities that make most of the loans that we do, if you're getting a loan from them, it won't apply. But if you're getting a loan from a non-reporting lender, the most obvious loan would be a hard money lender. They're not reporting lenders. They don't report their transactions to the federal government. Banks are already under regulations to report banking transactions. So a hard money lender, they don't report their loans and their transactions to the government. Bank of America does. So Bank of America is making a loan, no problem. Hard money lender making a loan, it's the same as all cash. So all cash transactions and non-reporting financing is affected by this law, this regulation. So the information required, who is supposed to make provide information are buyers, entity buyers, beneficial owners of entity buyers, the signing parties for entity buyers, trust buyers, entity trustees of trust buyers, individual trustees, and beneficial owners of trust buyers. So I'm buying a property into my trust, and it's an all-cash transaction. I'm going to have to, the escrow is going to ask me for information. I'm going to have to provide it, and it's going to be reported through this regulation. Individual sellers, entity sellers, trust sellers, individual and entity trustees of trust sellers. These are all parties that information must be collected from. So it's pretty broad if it applies. So it's a cash transaction, and the buyer is not an individual, or the seller's not an individual. Well, actually, they do collect from individual sellers. So, but again, only for cash transactions or transactions involving financing from a non-reporting lending party. Now, the information to be collected is legal names, birth dates, executions of the trust, addresses, DBAs, citizenship of trustees and beneficial owner of trustees. They want to know what country these people, the parties are citizens of, tax ID numbers, and account numbers and financial institution names from where the payment is coming from. No escrow is going to take a suitcase full of cash. They're going to require that cash be put in a bank, and then the bank will send that cash. It is a cash transaction, and so they want the information of that bank who received the cash and put the cash in. So it's not a huge amount of information, but it's not a small amount of information. It's a lot more than just a tax ID number that must be collected and provided to the government. It's provided to the Treasury Department within 30 days of closing. Again, let me stress this. No escrow company is going to close an escrow without having that information. Now, it closes November 28th. They ain't worried about it. it closes December 1st, they are very worried about it and they won't close. It's as simple as that. So this information must be collected, hence an addendum requiring the parties to provide the information. The delivery of required information within 7 days of receiving the request from the reporting person, which is again the escrow company. Deliver to the reporting person all necessary information to satisfy the reporting requirements. So escrow or associations are developing forms. I've seen some of the forms, and they will ultimately be developed. FinCEN may develop some forms. So they will provide forms to the buyer and the seller to fill out. Ultimately, some of these things may be done online. Our escrow organization, as with many, will employ a third-party entity to collect this information and then ultimately make the reporting. And the cost of that third party will be passed on to the buyer and seller and probably split, well, for sure, split 50-50 in escrow. So if there's reporting required or if it's necessary to collect that information, then there probably will be a unique charge for that in escrow. The buyers and sellers agree to make a good faith effort to acquire that information from any entity, beneficial owner, or trustee or signing party that is not the buyer or the seller. So the signing party is not a part of the contract. So I'm authorized to sign for my corporation. I'm not part of the contract. My corporation is. But the buyer and the seller will make a good faith effort to collect that information from me in order to satisfy the requirements of the FinCEN reporting. Hope that's kind of clear. Consequences of failure to provide that information. It's as simple as this. They will not close escrow. Keep that in mind. That's why we wanted to cover this in this class and wanted to give you a heads up right now. Not too many escrows are going to be affected by this, but as we get closer and closer to December 1st, this is going to be important. So starting now, any escrows you open now, you're going to want to, number one, get this form signed. The escrow will still not collect the information right now, but we want this form in place, and you want to have a brief conversation with your clients that it may be, if this escrow looks like it might close on December 1st or later, that escrow starting November 15th may contact us, contact you and ask you to provide information. And it's extremely important. I got to stress this. Escrow will not close. It's as simple as that. So you've got to be sure your clients understand that. Not getting this information is not going to be an option if they expect to close on time. Okay. Now, regardless, okay, they won't close regardless of whether that information is from the buyer, the seller, or third party. So they won't even close if like I said, I have a LLC and I'm signer for my LLC, but I'm not a party of this transaction. Personally, my LLC is. Why do I have to give my personal information? I'm not giving it. Well, then escrow won't close. It's as simple as that. So the other person who has to provide this information, we need to make a good faith effort to get that information from them. Okay, any buyer or seller provides or fail this information would be in breach of contract. And then the information from the third party, the beneficial owner, signing party, trustee, notifying the buyer or seller that the other party has failed to provide that information. And then we'll have to try to get the best we can to convince them to provide it, even though they are not a party to the transaction. Hope that's kind of clear. This is going to be real, I think, problematic for a while, because we're going to have entities, signers, not wanting to provide this information. That's why they have an entity, and they're going to be concerned about that. And if they're the signer, their entity is a part of the contract. You can give the entity a notice to perform, but you can't give the signer a notice to perform. I hope that nuance is kind of understood. But regardless of that nuance, if we don't get that information from the signer, even though they're not actually in the transaction, their entity is, but not them personally, they still have to provide it. We don't get it, escrow doesn't close. All right, by signing below, buyer and the seller agree to these terms. of this addendum. Now, this addendum's a standalone addendum today because Carr had to put something together quickly to make sure that we're prepared for those in this December 1st and later closings. This addendum will probably be eliminated, and the terms of this addendum will be incorporated into the various purchase agreement addendums, purchase agreements as applicable. All right. Now, if you got some questions on that, just put them in the chat. Lindsay, as most of you know, will help me with answering any questions at the end of the presentation. Okay, let's talk about the Multiple Listing Service Addendum, the MLSA. That's been revised in some ways extensively, and in some places extensively, and in other places not much. I do want to review this with you because I want to be sure everybody understands the new guidelines that NAR has put out, and that the two MLSs that we are mostly concerned with, the CRMLS and San Diego MLS, how they are adopting those guidelines. The NAR guidelines that were put out recently are not mandatory. They're simply guidelines. The MLSs have till the end of September to adopt them or to clarify what they're not adopting. And so I think that's been done by both CRMLS and San Diego MLS, and I'm going to review that with you here toward the end of this particular section of this presentation. So let's look at the addendum, and we'll review it briefly in some places and a little more detail in others. So there's nothing different here. It is incorporated into the listing agreement because there are some elections that are going to be made on this addendum that will be a part of the listing agreement. So this is, of course, most of you know, all of you should know, it is a mandatory form, and it needs to even be executed so that whatever you're doing relative to the MLS with your listing, you have the seller's acknowledgement and agreement that that's what's happening. Now, the first paragraph, not much has changed here. The multiple listing service, they talk about what is an MLS. They talk about realtor-owned MLSs, which both of our MLSs are. Both CRMLS and San Diego MLS are realtor-owned. What information is provided to the MLS after the sale of a transaction, and what MLS does the broker belong to, and that's specified, and that is, again, there's nothing new in this paragraph 1, nothing to worry about that. The benefits of using the MLS and the impact of opting out of the MLS, this hasn't changed much either. Exposure to buyers through the MLS, the impact of not putting it in the MLS, the reduction of exposure, and then not listing a property in a local MLS. So you put it in MLS, but you put it in MLS, it's not the MLS where the property is located. It's the agent's MLS, but the agent's taking a listing out of the area where he does belong or she does belong to the MLS, puts it in that MLS, great, but may not be beneficial to the seller. Again, paragraph 1 and 2, pretty much same thing as before. Paragraph 3 begins to make a few changes. Nothing real significant. I'll review them quickly with you. Paragraph exclusive seller reserve listings for residential real property 1 to 4 units must be submitted to the MLS within 1 business day of any public marketing. So if you have an exclusive listing or a reserve listing, by the way, you're not going to have any reserve listings. I'll explain that in a minute. No, I'm sorry, seller reserve. Yeah, you do have those listings. So exclusive listings and seller reserve listings. What is a seller reserve listing? A seller reserve listing, well, let me back up. An exclusive listing is seller sells the house, listing agents paid. That's the blunt language of one of the benefits of an exclusive listing. I'm going to go to work marketing your property, but you sell it to your next door neighbor on your own. You still owe me a listing, a commission, because I have an exclusive listing agreement with you. So our listing contracts are exclusive, called exclusive right to sell. A seller reserve listing is like an exclusive with the exception the seller may reserve a specifically identified party. And that's okay too. That's often used when you're listing for sale by owners. Or a seller says, yeah, I want to list with you, but my neighbor's told me he's always wanted to buy my house. Or my friend has told me he always wants to buy my house. And so if I sell it to him, I don't really need you. I don't want to pay you this commission. I might pay you something to do the paperwork. So that's the seller reserve listing. The seller is reserving certain parties that if they buy the property, you wouldn't be paid. And so when I used to list or sell, I listed a lot of FSBOs, and that was not an uncommon argument that the seller would make. Well, I don't want to list it yet, Walt, because I've had a few people through my open house, and one of them told me he's going to come back and buy it. Yeah, I'm sure he will, but that's not my dialogue. But all of you who've done, for sale by owners, you know what I'm talking about. They think that all those people that told them their house is beautiful and they're really going to think about it. It's just like going to a store and you don't tell the salesperson, no, thank you. You say, well, I'm going to go home and think about it, right? So they want to reserve those particular buyers. That's fine. Each person makes their own business choice, but I don't think I've ever been burned by that. And so that's what that is. All right. So that must be entered within 1 business day of any public marketing. That's clear cooperation. Okay. Now, public marketing is defined here. So it's flyers and yard signs and digital marketing, which is Facebook and all those different things, social media, websites, all of that sort of thing, email blasts, that's all public marketing, and that's defined. Again, no elections are being made yet. We're just defining things and explaining things. Uh, Private marketing permits agents affiliated with the broker to engage in one-on-one promotion of their listings, of the broker's listings. So we can promote our listings to other agents within our brokerage, even if it's being privately marketed. We're not promoting it to the general public, but we can promote it to anybody within our brokerage. That's fine. And then different status options are available, and we're going to go over those status operations in a moment. This clear cooperation policy is on this form because it's a statewide form. This clear cooperation policy does not apply. Paragraph is on the form because there are 2 MLSs in the state. I think they're both in Northern California that do not have clear cooperation policies. So if you're a member of those MLSs, which none of you are, then that you'd be checking that box. So you can ignore that 3E. Checking it, some agents believe, and let me correct you on that if you do, that checking that means that you can be exempted from clear cooperation policy. No, you can't. Both CRMLS and San Diego MLS has adopted clear cooperation, and as a member of those MLSs, you cannot opt out of clear cooperation. So don't misunderstand 3E. It is not an opt out of clear cooperation. It's to make the form universal to everybody in the state because, like I said, 2 MLSs do not have clear cooperation policies. All right. 4, property listing information on the internet. Again, this isn't significantly changed either. It's pretty much what it's been before. Total internet opt-out. You can opt out of the internet completely, or you can have limited internet information opt-outs. So certain information not provided to the MLS. The property address can be, not provided to the internet. Property address can be excluded from the internet. Again, that's an election that you'll make later on the form. Feature opt-outs, comments and reviews. A lot of agents like to opt that out because they don't want other members of the public making comments about the listing. And the big one is automated estimate of value. A lot of listing agents, and I understand that completely, don't like that because the seller gets a false sense of what the value of the property is because those automated estimates are sometimes not very reliable. So you can opt out of that as well. Okay, marketing options. That's where the form has been heavily revised. and it reviews the different options that that a seller and a listing agent can agree to. Okay, so the default is full exposure. It's going in the MLS and it's going everywhere. So that's the default, and that is typically many listings taken. They just go with the default. All right. Now, the next option is delayed marketing limited exposure. That's a new status created by NAR when they did these revisions, and it was done mostly to accommodate, guess who? Compass. So they created this category to allow some exposure, but limited exposure, and you can one-on-one. It's. I'm not going to spend a lot of time explaining it because uh, you're going to find out in a minute that option's not available to you. Okay. Coming soon explains coming soon, but there's no statewide definition of what coming soon means. And you will see later that CRMLS and San Diego MLS have a different definition of the features or the parameters of coming soon. So the seller's advised to discuss coming soon with the broker because there's no one universal coming soon rule. Now, it is universal to the specific MLSs. So those of you, most of you in Irvine are probably CRMLS members and not San Diego MLS members. Agents in San Diego, many of our agents belong to CRMLS as well as San Diego MLS, or one or the other. So CRMLS is different. Their rule for coming soon is different than the rule for coming soon in San Diego MLS. And I'm going to give you a handy dandy little guide that you can take, refer to, and I'll ask Aunt Lindsay after I'm done presenting it to you to actually email it out to everybody. So that'll help a little bit. And then office exclusive limited exposure. In other words, keeping it out of the MLS. It's an office exclusive, and that is defined. Days on market talks about days on market is unique on how it's calculated, and there are rules about photographs. Those two have not changed much either. Okay, now this is where the big change is in this form. This is page 3 of the MLSA, and that is where elections rather, are made. And the goal of CAR, and I appreciate it, even though I don't list or sell, I would think that you would appreciate it as well. It's sort of bringing the MLSA into the same concept as the forms that have grids on them. The beauty of the grid is all of the things you got to elect. Do you want A or do you want B? That's in one place. It's not buried throughout. In the case of the RPA, a 17-page document, it's right up front. Well, the MLSA is the same way. It doesn't actually have a grid, but everything that you need to elect is right in back. It's the end of the form, page 3 of the form. And that's where your elections are made. Everything up until now, there's no elections. It's just explanations. But now we're going to make elections. So the first election is whether or not the property information, how is it going to be handled on the internet? And so you can check a box and totally opt out of any placement or distribution, rather, of the property to the internet through an IDX feed. So that's a complete opt-out. Or you can have limited opt-out. We already mentioned it before a little bit, but now you make the decision with the seller. What do you want to do? You want to opt out the property address? Do you want to opt out specific features, the comments and reviews, or the estimated value? Talked about that. You can opt out of that, and the seller can elect to confirm that with you. You put that right on the form. Now, the marketing option, paragraph 2, is the default is full exposure. So there's the different ways it will be marketed in the MLS, or not in the MLS for that matter. So full exposure, that's a default. It's just going to go into the MLS like it's supposed to, and it's going to be in the MLS starting with the beginning of the listing period and be there, available to everybody in the MLS. That's the default. So if you're going to keep it out of the MLS for week or two to get it ready, you need to check a different box in this paragraph. Now, delayed marketing exposure is one option. It's only applicable if it's allowed by the MLS. And as I said, it's not allowed by CRMLS or San Diego MLS. CRMLS is pretty much keeping their rules the way they were before, and I'll review them with you. San Diego MLS has broadened the definition of coming soon to take advantage of delayed marketing limited exposure features. So you'll see that difference in a moment. Coming soon, check the box. Now, this is a little bit different. I was talking to an agent, in fact, yesterday, and before the default was the agent decided whether he'd put it in coming soon or not. I would argue now it's a mutual decision between buyer and seller. If you're going to put it in coming soon, you want the seller to acknowledge that it's going to go into coming soon. If it's an office exclusive, it's not going to go in the MLS, at least not immediately. You would check that box. Now, the default is it never goes in the MLS during the entire listing period. Or check a box, keep it out of the MLS until such and such a date. Pick a date, and then if you want to put it in the MLS sooner, or you're not ready to go in the MLS at that date, then you do a modification of terms, LA, listing agreement, MTLA, and then change the date in paragraph 2D2. Marketing option, office exclusive, when do we begin marketing, 2D2. All right. Other in terms are pretty straightforward, not a big change there. It's about photograph seller, photograph instruction. Visitors are not restricted from taking images of the property when they're in the property. A lot of agents go into properties and take their own virtual tour, if you will, to send to their buyers. You want to make sure that that's not prohibited by the in the MLS. In other words, that the listing agent has not put in the MLS no photographs. Some sellers don't want people going in their house and taking photographs. So you should check the MLS because you would be in violation of the MLS rules if you took photos of an interior of a property and the seller specifically stated, nope, I don't want any. And see, so that's the box that the sellers are not restricted. I'm sorry, the visitors are not restricted, or they check a box. The seller says, no, I don't want you to take images of my property. And that is put into the MLS, and it's up to the buyer's agent to be aware of that. Pretty much it completes the form, obviously, and it is an addendum. All right, now let me do a listing status comparison for you. I mentioned this before, and that's where we're going to compare office exclusive and San Diego MLS coming soon and CRMLS coming soon categories, if you will, statuses. And I put together, actually, Emily put this chart together. I gave her the notes. I plagiarized some of it, and I made some of it myself, but I didn't type any of it. So what you're looking at is, thank you, Emily. So we'll go down to certain features and whether an office exclusive it requires it, a San Diego MLS requires it, or CRMLS requires it. So a listing agreement, obviously it seems like you wouldn't have to say that, but believe it or not, people have put things in the MLS and excluded it. I mean, they're not putting it in. I mean, people have taken things and put them in the MLS, but they don't even have a listing yet. So you have to have a listing agreement before you can put it in the MLS in a coming soon status, and an office exclusive, you wouldn't be putting it in the MLS anyway, but you have to have a listing agreement, even have an office exclusive, obviously. Seller consent required, yes. And we just talked about it. The MLSA can do that for you. All three require the seller consent in order to have it as an exclusive, have it as a coming soon in San Diego MLS, or have it as a coming soon in the CRMLS. Public marketing allowed? No. There is no public marketing allowed in office exclusive. There is public marketing allowed in San Diego MLS coming soon and CRMLS coming soon. However, the marketing in CRMLS, the rules say that you must, in any of your marketing, like posts or advertising, mail outs, anything like that, you'd have to indicate it's in the coming soon status. Not a big deal there yet. Can you have yard signs, flyers, email blasts? No. Office exclusive, no yard signs, no flyers, no email blast to the public. San Diego MLS you can, CRMLS you can. Social media marketing, no. Office exclusive does not allow social media marketing. So if it's excluded from the MLS, it cannot be advertised in social media. You can advertise coming soon, and you can advertise in both MLSs, San Diego and CRMLS. Showings allowed, yes, but only within the listing firm. So if you have an office exclusive and you want to show it or another agent wants to show it, you can in fact show the property. San Diego MLS, now this is a big change. I reviewed this with the San Diego agents last month, that you can show coming soon listings if it's in the San Diego MLS, but only on a one-on-one basis. So that means no open houses, obviously you're going to see that in a minute, and no caravans. You'll see that in a minute. But you can call up an agent from another brokerage and say, hey, remember you told me you were looking for a property, such and such. Well, I've taken a listing that way. Let me tell you about it and give you the MLS number, and you can go ahead and show it one-on-one. One broker to one broker. That's allowed. That's a change. That is San Diego MLS trying to adopt that new status of delayed marketing limited exposure. But they haven't adopted it, but they've tweaked their coming soon to take that into effect. CRMLS, no. And this is critically important. I'm very familiar with San Diego MLS rules and regs. I'm on a first name basis with the manager of rules and regs, and I'm not as familiar, but I do talk to them from time to time. It's not easy because they're not as user friendly. But Ed Zorn is their chief legal counsel, and he explained something to me, and I think it's kind of interesting. They have certain rules that they believe that once you break the rule, the damage is done. So you cannot appeal. You can appeal it, but you're not going to win. You can't ask for forgiveness. You'll never do it again. You are going to be fined what the rule says. Showing a property that is in coming soon carries with it a $2,500 fine. That's $2,500. And Ed Zorn tells me they enforce that strictly because you can't undo it. You're not supposed to show it. You do. You broke the rule. You can't say, oh, I'm sorry, I won't do it again. No, you already did it once. And they have a handful of rules like that. This is one of them. So all of the members of CRMLS, please don't get yourself in trouble, because you get caught, you're not going to be able to get out of that. Okay, displayed in the MLS, office exclusive, no. San Diego and CRMLS, yeah, they're displayed in the MLS, of course. Photo required, no. Office exclusive, no photo. Yes, for both MLSs, an exterior photo that shows substantially the entire property, not a photo of the front door. That's not enough, okay. Can it go to pending without going through active? No. You can sell an office exclusive, but if you want to put that sold in the MLS, you haven't put it in the MLS yet because it's an office exclusive. You have to put it in active and then immediately move it to pending. Not so with coming soon in CRMLS. You can take something that's in coming soon and move it right into pending. So that's kind of nice. Okay. Open houses, broker tours, caravans, no, no, no. You can advertise. CRMLS has a unique, they specify that you can advertise an open house, but before the open house is held, you have to move the property to active status. So you have it in a coming soon status on Monday, you're advertising it, you're promoting it, and that's okay. when you hold the open house on Saturday or Sunday, it has to have already been put in the active status. That's the rule. Syndication, no. None of them are syndicated. And days on market, office exclusive doesn't count, obviously. It's not in the MLS. And days on the market begins when it converts to active status. CRML has a specific designation, days active in the MLS, DAM, with CRML. Some of you may be familiar with it. A maximum duration of the status. You can have an office exclusive the entire duration of the listing. Same with a San Diego MLS coming soon. Again, the rule was changed to accommodate that the features of delayed marketing limited exposure. So San Diego MLS, there's no limit to how long it'd be coming soon. CRMLS maximum time is 21 days, like the old rules. Okay, so I hope that's clear. If you have any questions, I'm going to send you that entire spreadsheet, if you will. I'll ask Lindsay to email that out to everybody so you have a handy dandy reference chart. And keep in mind that that's effective rules as of today. If there's any significant rule changes, hopefully I'll be aware of them and announce them at future classes, or we'll do a announcement. Let me talk about the DRE regulations implementing AB 2992, which is the regulation requiring buyer representation agreements. So let me run through that quickly. It looks like we'll be able to, it looks like I'm going to be able to finish pretty much on time and have some time for questions at the end. So, okay. So term limitations. The law says 3 months. The DRE says it's 90 calendar days. So you've got to no longer, you will be in, if you violate the law, let me back up a little bit. If you violate the civil code, with your listing agreement, your entire listing agreement is unenforceable. So if you have a term longer than the law allows, it's not just that provision that gets thrown out. It's the entire listing agreement. That's what the civil code says. You know, the RPA, what am I talking about exactly? Most contracts, the RPA being one of them, says that if any provision is deemed to be contrary to the law or thrown out, the rest of the contract's still good. And that's real common with contracts, okay? The civil code says that if any provision in the contract violates the civil code, the entire agreement is unenforceable. Now, that's an interesting nuance because, for example, the civil code doesn't cover everything that's in BRBC, but it covers certain things. So there is a provision in the BRBC that if a certain clause is unenforceable, the rest of the contract is still good. But that does not apply to those provisions that are mandated in civil code. Hope I haven't lost you yet. Term limits, not term limits like elected people, the limitations of the term of the agreement, that is mandated by civil code. And that is going to be 90 days. So let me get right to the point here. Stop doing something like July 30th to August, September, October 30th. Count the days, because if you include a couple of months with 31 days, you're not going to be able to do it for 3 months, even though the law says 3 months. But the DRE says, no, 3 months means 90 days. So right from the mouths of Gov. Hutchinson and Carr Legal, listing agents should count days and then have the expiration on or before the 90th day. Okay, the 90 calendar days shall start upon the agreed upon date, whatever the date the listing agreement says it's going to start. That'll be day 1. So this listing agreement is going to be effective, what's today's date? I don't even remember exactly, but let's say, August or September 10th. All right, it's effective on September 10th. That's day 1. And then you count day 2 is 11th, day 3 is 12th, and you go right forward. So the first day is the day the agreement starts. The 3-month term limit shall not apply to buyer representation agreements between brokers and corporations, limited liability companies, and partnerships. So if you're listing a property, the owner is a corporation, a limited liability company, or a partnership, then that 90-day limitation does not apply. Buyer broker agreements cannot renew automatically, don't have any renewal that's automatically. By the way, back to that term limits, limitations of term, it's the DRE didn't specify that the continuation period is also 90 days. But the conventional wisdom at Car Legal, and I agree with them, is that's probably how it'd be interpreted. So a protection period, a so-called protection period, actually a continuation period on the BRBC that is greater than 90 days, in all probability could invalidate the contract. We're working on a contract right now where the previous listing agent put in a continuation period of 120 days. It's probably in violation of the DRE regulation. It's for sure a violation of the code because the code says 3 months and they went 4 months. Okay, renewal buyer broker agreements shall be in writing. You have to have a written renewal signed by all the parties and shall not exceed the 90 days. 3 months is defined as 90 days. DRE defined 3 months as 90 days. Renewal must be executed at the end of the listing agreement. It can't, a day or two before, a week before, that's probably okay. You can't renew a listing agreement the first month of a 3-month agreement. That's going to be contrary to the DRE intent. They don't want renewals done until at the end of the listing period. It doesn't have to be the very last day. It does have to be done before the expiration, though. So that's why doing it on the very last day is not required. Doing it on the first month, the end of the first month, probably not right. Toward the end of the 3rd month, toward the, on the 80th day, the 85th day, that's probably fine. It doesn't have to be the day before expiration. Civil code provides that buyer representation agreement shall be executed between the buyer, agent, and the buyer as soon as practicable, but not later than the execution of the buyer's offer to purchase. That's what the civil code says. Now, as realtors, members of the CRMLS and the San Diego MLS, we have to execute the buyer representation agreement before showing property. But what about our competition? They get to execute a buyer broker agreement before they write an offer? Maybe not, because there shall be a rebuttable presumption that it is practical for a buyer's agent to obtain a signed broker agreement before showing property. Now, rebuttable presumption means this is true, what we just said, unless we can prove otherwise. So this is true that you can get a buyer agent agreement signed before you show property, unless the person in violation of this guideline can prove that it wasn't possible. That's what rebuttable presumption means. I'll give you a perfect example of rebuttable presumption. It's enshrined in our Constitution. You are innocent until proven guilty. So it is assumed you're innocent, but somebody can prove, no, you're not. The prosecution can say, well, in this case, not so innocent. So the same with this. You can get this signed before you show property. So that goes a long way to making non-NAR members held to the same standard as NAR members. You have to have an agreement before you show property. You can only get away with not having that agreement before showing property as a non-NAR member if you could prove you couldn't get it. As a NAR member, you don't have that option. You have to have it, period. And of course, the intent, CAR's intent on promoting the civil code requiring buyer representation agreements was to bring non-NAR members under the same rules as NAR members. And the DRE went a long way to helping us with this specific guideline. Virtual showings occur when a buyer's agent, at the direction of the buyer, enters into the property, onto the property. You have to have an agreement before virtual showings. So if I go out and take pictures of a property and then send them to my prospective buyer, I have to have a buyer representation agreement. And to provide that the buyer who's not physically present, okay, just an explanation of the more of it. Okay. The seller's agent acting solely on behalf of a seller is not acting as the buyer's agent in showing property to potential buyers, whether at open house or any other showing. So again, DRE put in their regulations, which now practically becomes code, that at open houses, you don't need to have buyers sign buyer representation agreements for them to tour your open house. You can do what we've taught you already. If you are showing a property on behalf of your listing, you're showing it on behalf of your seller. So a buyer calls you up and wants to see the listing, and they don't want to sign a buyer representation agreement, but they still want to see the listing. You can show it to them, but you're showing it to them as an agent of the seller. Of course, you're not a buyer's agent. So in previous classes, and anybody needs some help, call me one-on-one. You'd have some dialogue. Look, I can't advise you, I can't guide you, but I can certainly show you the property. I can answer you very specific fact-related questions. How old is the roof? I can answer that question. That's not advice. Do you think I need a new roof? If I buy this house, that would be advice. I can't do that. You haven't signed a buyer representation agreement. That's sort of a very fractured example. Okay, folks, that completes the transaction. I mean, the presentation. Lindsay, do we have any questions?
Yeah, we do. So, Mike wanted to know what the federal act was that you mentioned in regards to the FRR-PA.
That it wasn't a federal act. It's a ruling by the Treasury Department. It has the full weight and force of law. Now, interestingly enough, the reason they didn't incorporate it in the RPA immediately, they being CAR, there's at least 2 fairly significant lawsuits challenging that requirement. But that's a requirement published by the Treasury Department and fully enforceable. But one party, both parties are suing on various grounds. One grounds is it's unconstitutional and invasion of privacy. I'm not sure of the details of the other lawsuit. So those lawsuits are in place, and the hope is those lawsuits will be significantly advanced to the point that we'll know better toward the end of the year whether or not this is here to stay for a while. And that's when CAR will put it in the RPA. They didn't want to revise the RPA yet because they don't know how these lawsuits will shake out.
What's the best way to reference it, Walt?
I'm sorry?
What's the best way to reference
That it's
it?
a Treasury regulation with the full force of federal law.
Okay. Thank you.
Hello.
And
Hello.
again, stress, as you talk to folks, stress, this is an anti-money laundering regulation. And so, I know I agree with you. It's a pain in the neck that we have to do this, but there are nefarious people doing, bad things and making a lot of money at it, unfortunately. And the government's trying to rein that in.
Hey, Walt.
Yes.
Yeah, this is Azim. We had this situation about 6-7 months ago. I'm a board member of a HOA, and FinCEN required all the board members to have to fill this form and, about their income and all those things. And then after a few, and then it was a lawsuit, and then we were advised from our attorney, they dropped it. Now we don't have to report.
Right. Azim, that's not the same thing as this. What you're talking about is the GTO. The GTO, which Southern California is a part of the GTO regulations, They this is GTO is much more broad, is much more narrowly defined, but they did, the GTO regulations, some people overreached that a little bit. So this, the fact that has nothing to do with this FinCEN new regulation. So,
Actually, I had to go on the FinCEN website and register.
right.
I did register, but then a month later they told me, they
Right.
dropped
But
it.
again, Azim, please, this is
Yeah.
nothing to
Okay.
do with what I'm
Okay.
talking about.
Just wanted to bring to your attention.
It's just it was an overreach, at the time. And that, I think, quite frankly, probably a lot of people said, hey, wait a minute, we're not doing this. You have no authority to do this. It's not what the regulations say. And that's why these new regulations, probably part of why they came out. Next question, Nikki.
Do
Walt?
you know what the cost of the reporting is going to be
We
when we
don't know. We don't
Okay.
know yet. Escrow will probably determine that and then advise people of that. Again, escrow's not going to do anything until November 15th, right around there. We, as agents, want to be a little more prepared because we want our clients to understand this, because you take a listing today, there's a good chance it won't even go into escrow until December 1st. And so you want your listings to sort of let your sellers know this, Same with buyers. If you got an all cash buyer, if it's going to close escrow November 1, you can say this probably won't affect you, but if it bleeds into December 1st, might be a good reason why we do everything we can to close on time. This could happen. Escrow won't be asking for this information until around the middle of November.
I think Marcelo has a question.
Go ahead, Marcelo.
Hey, thanks for just for providing us this information. Do you mind clarifying again when you mentioned about the showing a property like on a FaceTime or on a video to a prospective buyer? Is that what you just said, is that we must have a buyer broker agreement signed in order to be able to either show it on a video tour or
Yes.
send in a video?
Yes, we do, because we are all NAR members, and we are all members of San Diego MLS or CRMLS. And so NAR requires that we have a buyer representation agreement before we work with a buyer. Both the San Diego MLS and CRMLS rather, require buyer broker agreements before you show property. So, and showing property can be defined as virtual tours. You provide a buyer with a virtual tour of the property. You are in fact showing the property. And of course, on the other side of that coin, you're protected, because that's very definition of your involvement in a property. So you do a virtual tour with a buyer, you have a buyer representation agreement with that buyer, and he ends up buying another property, or buying that property rather, with another agent. You're protected because you were involved in that property. So you are required to have a buyer representation agreement. Again, for us, being NAR members and members of the CRR-MLS and the San Diego MLS, when we work with buyers, before we even work with a buyer, we're supposed to be having a buyer representation agreement. The Civil Code didn't initially make it that broad. They said as soon as practicable, but not later than when you write the offer. So that's where DRE did a favor for all the NAR members, telling the NAR members that you're going to have to prove it wasn't practicable, which, you can do it. You're going to have to prove you couldn't do it when you first worked with the buyer, because we're going to say before you show property, you have to have one unless you can prove you couldn't get one. Now, NAR doesn't have that unless you can prove you couldn't get one aspect of it.
Got it. But that does not apply for open houses, right?
No, as long as you're doing an open house for a either Remax Premier or a Remax Connections listing. If you do an open house for a seller that is not listed with our brokerage, then you'd have to have it, because you're not working for the seller. But if you are, if the house you're holding open is a Premier, Remax Premier, or Remax Connections listing, then it is argued that you are doing that as an agent of the seller, and we already have that. We have that listing agreement.
Okay, and if you are holding an open house for a company other than Remax,
Yeah.
because now we're seeing agents, this is basically cooperation, collaboration.
Right.
How were we supposed to be handling with the
You
buyers
got to get a
coming into the house?
you got to get a buyer representation agreement before you
When they
theoretically.
walk into the open house, you mean?
Yeah, well, now you're not a policeman, so if somebody comes in and wants to see the house, you would need to make a good faith effort to get a buyer representation agreement. But if they say, "I'm not signing anything, get out of my way," you get out of their way. We're not going to make you policemen. But
Gotcha.
you don't want to encourage that. You don't want to say things like, "Yeah, no problem. Let me show you the house. Let me walk you through it," because you got to have a buyer representation agreement to do that if it's not
Got it.
either a Remax Premier or Remax Connections listing.
Thank you.
Can I add a question to that, Walt?
Sure, of course.
It's Libby.
Hi, Libby.
So if you have lead generation and somebody, emails you and says, can you show me a picture of, or can you describe or something, the house on what's and what's, or you get a lead generation that says they're interested in this house. You don't have to get a BRBC before you actually send them a photo, do you?
Probably not. You can probably get away with you're just responding to an email, but you would want to very soon if you're working with them. You haven't met them yet, you haven't shown them property, but you're starting to show them lots of stuff online.
Uh-huh.
Again, there's not police out there looking for you
Sure.
to do this, but you want to keep in mind you start doing a lot of stuff for them, and it protects you as well.
Yeah.
You're going to want to get a buyer representation agreement because the NARS settlement and their regulations say working with. So, are you working with them when you send the first email? Yeah, but nobody's going to worry about that. But you're sending them multiple emails and you're
Third or
doing
fourth,
searches on it.
you are.
Yeah, that now you want to say, and I would argue, and again, if you need dialogue, I used to do nationally, many of you know, I used to do sales training at a national level for nearly a dozen years. So I got tons of dialogue. Some of you know that. And I'll help you, but you'll want to get a BRBC before you do a whole lot for somebody. But yeah, one time responding, yeah, no problem, here it is. And again, if it's on a company listing, then you're doing it as you're facilitating the sellers, our obligation to the seller to get their home sold.
Okay. Thank you.
Great question.
And the next one is, when do we get this addendum signed during the transaction? When can we inform our clients? But does escrow do the addendum?
Well, this addendum should be signed as soon as practicable. You should probably start doing it now when you go on listing appointments or when you meet with buyers. Escrow is not going to be doing a lot with this. Barb can chime in and correct me if I'm wrong, but they're not going to do much of anything until mid-November. Mid-November, they're going to make sure that they get in place this information so they have it because they don't see why are they doing it because they don't want to delay your closings. So mid-November, it still hasn't closed. Oh, no, don't worry about it, Barbara. It's going to close November 28th. Yeah, but if it doesn't, I can't close it. That would be Barb's dialogue. I tell Barb, never tell people what you can't do. By the way, it's a good sales tip anyway. Tell people what you can do. But she cannot close an escrow on or after the December 12th. None of your escrow companies can. Nobody can. Without this information. So they're going to start trying to collect it in late November, mid-November to later. So they're ready to move forward. Oh, slipped from November 30th to December 1st. No problem. I got all the information.
So what point during the transaction do you get it signed? Like with the listing paperwork, with the purchase
Great
contract?
Question. We would like our agents to get this form signed going forward with any escrows you open. And you should get it signed when you take listings and write offers now. But certainly when you open an escrow, you're going to want that signed because that's just being proactive. Your clients are going to love you when you explain, and then you can tell them, I'm not sure this will even apply, but I want to be sure you understand this, and we get this in place. And they're going to like that they're not being surprised. The worst thing, I say this all the time, not to get off on a tangent here, or just keep it brief. One of the worst things you can do to a client is surprise them. Prepare them for the worst in advance. Prepare them for what could happen in advance. They'll love you for it. And then if it never happens, they might say, "Oh, Walt, you were so worried that XYZ would happen." Yeah, I know. It didn't happen. Isn't that great? Now, you're not mad at me, are you? See, they're never going to be mad at you because you told them in advance what could go wrong. That's not, people sometimes misinterpret that as being a negative thinker. I'm not negative. I'm not a pessimist. I am an inversion thinker. Inversion is you think of what can go wrong and then prepare for it. Doesn't mean you're thinking it'll go wrong. You're just prepared when it does. And optimistically prepared. Okay. Next one.
The 90-day term limit is only for the BRBC, not the listing agreement, right?
You're exactly right.
Okay.
Yeah. The civil code on listing agreements is 2 years.
Okay. Is it okay to put a continuation period of 90 days for the BRBC in section 2E3?
I would, yes. Yeah, I would not do it more than 90 days, but 90 days is fine. I've seen 30 days, and my comment is not much help, not much protection. Those of us who've been in real estate for a while, the continuation period, they never named it in the past. This period of time after the listing expired, you're still protected. We used to call it the protection clause, never officially called that. Now they have named it continuation period, which I like much better than protection clause. What are you protecting yourself from? So continuation period is beautiful, but hence my statement, not much protection there.
Did
the 30 days.
Did the BRBC explanation say you can send a photo of a home without the BRBC signed?
Yeah, he
yeah.
answered that.
Oh, he
That was
didn't.
me. Yeah,
Sorry, Libby.
Sure.
Let's see. The FRR-PA is already part of the RPA bundle, and I should mention it's already on the SkySlope checklist as well, so you guys can upload it now. Just want to make sure this does not need to be signed if the client's getting a regular loan, not the hard money loan.
Exactly right. Keep in mind, this is for cash transactions. Now, I would you're also not going to have to do anything for a cash transaction where the buyer is an individual. So Walt's client is buying a house, and Walt and Diane are buying a house. We're individuals. We're buying a house. Now, here we got to keep in mind, that's why you should get it signed. Halfway through escrow, I want to assign it to my trust. Now, if it closes December 1st or later, it suddenly kicks in. So assignments to trusts and to LLCs, an individual bought it, but now I'm going to assign it to my LLC. This is going to kick in for cash transactions that close on or after the 1st. So you want to have this form. This form doesn't ask for any information. This form simply does 2 things. It explains what could happen, and I wouldn't explain it this way, but binds the buyer and the seller to providing that if they're asked. So it informs the buyer and the seller that they are going to be required, they are going to be required to provide that if it closes later than on the 1st or later, if it's a cash transaction and you're either an entity or you're signer for an entity.
That's it.
Well, that's great. Not a lot of questions, so I guess we covered it pretty well. Thanks,
one last
everybody.
Wait. Someone has a question.
Go ahead.
Oh,
Sorry.
am I talking?
Yes.
Okay, this is Emma from Irvine.
Hi, Emma.
Emma.
Hi. So
Hi.
question about how to trigger this reporting. So if a buyer eventually they want to be in trust, should we advise them to buy the property on individual, then after close of escrow, transfer to their trust? Is that a good advice?
My style, Emma, and those that know me know, what I do, you know, more often than not is I wouldn't advise a seller to buy it and then transfer it into trust. My style is to say you got two options. One is buy it as an individual, and then after, transfer it to a trust, or you buy it right into a trust right away. And
Mm-hmm.
then discuss with them the pluses and minuses of each option.
Mm-hmm.
See, I
Okay.
don't really tell buyers or sellers, what they should pay for a house or what they should write their offer at or what they should list at.
Yeah.
I don't say, I advise you not to overprice the house. Not maybe semantics, but I can tell you it's better sales skills, in my opinion. Look, you can overprice the home. You can price it what I'm suggesting. That is your choice.
Mm-hmm.
I'm recommending that if you do overprice it, it's going to take longer to sell. I'm going to
Mm-hmm.
suggest. See, so
If
I'm
it
giving them the
sells.
consequences.
Mm-hmm.
So if you want to be in your new home by such and such a date, how would you feel if you can't be because maybe you couldn't sell the home as quickly because the price was low? See, I'm going to let them advise themselves, but I'm going to guide them. I mean, this is not a good forum to do this. Those of you know me, you know how I am. But I'm going to spend time asking them questions because if they decide this is what they want to do, they're not going to argue with themselves.
Okay.
So my goal isn't to tell them what to do. My goal is to get them to tell themselves what to do, but to tell themselves the right thing to do, which is what I'd like to tell them what to do. But again, I'm going to get them to tell themselves because it'll have more weight. I don't know if that makes sense or not, but so I would, to answer your question directly, I wouldn't necessarily advise them,
Uh-huh.
but I would let them know now if you just transfer it to a trust later, I don't believe this reporting will be necessary. So if that concerns you, let's buy it as an individual.
Okay. So, and we actually do not know if they buy as individual then transfer after close escrow. Will that trigger the same thing or not? Do we know that?
We don't know that. That was a great question because as I was
Yeah.
answering your question, I said to myself, I wonder if transfers
Yeah.
would trigger that. I don't think they would because when they sell, that's when they're going to get, that's when it's going to.
Oh, okay. So a related question is, when we advise the seller getting a listing agreement, we disclose this new regulation.
Mhm.
And what we are explaining is if the certain buyer coming as required to report, so does that mean in the escrow will, for this transaction, will ask for the same detailed information from the seller? That's why we advise them, let them
Yes.
know what's happening, right?
Yeah, the answer to your question is yes. There's information that the seller must provide and
Oh,
information
okay.
the buyer must provide. Exactly.
Oh, okay. 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 Mm-hmm.
Good question.
I think that's
Any
it.
other? All right,
Oh.
folks. Thanks for jumping on. I hope you found it helpful. If I don't see you before, we'll see you in a month from now, and we'll see you at the office meetings for sure.
Mhm.
And call if you get lonely. If you need anything, I'm here. Weekends and evenings, fine. Never a bother. So take care, everyone.
Thank you, Walt. Bye,
Thank you.
everybody.
Ciao.